Hello everyone. In this presentation and the next one, the principles of vicarious liability in torts will be explained. A person can be liable for a tort when he does an act which infringes or violates the right of another, causing injury to such person. Thus, the general rule is that a person who does the wrongful act will be held liable for it. As exceptions to this rule, there are certain situations wherein one person can be held liable for the wrongful act of another, though he is free from any personal fault. The principle of vicarious liability provides for such situations. Vicar is the person who performs the functions of another. Vicarious is one being held liable for the act of another because the act is performed on his behalf. The principles of vicarious liability rests on two maxims: respondeat superior and qui facit per alium facit per se. The first maxim means that the superior, that is, the master or principal, has to answer for the acts of his subordinate. And the second maxim means that he who acts through another is deemed to act in person. Vicarious liability can be imposed in three situations: 1 by ratification, 2 by relationship, and 3 by abetment. What is ratification? When a person adopts or approves a transaction, though originally he was not bound by it because it was entered into by an unauthorized agent, he is said to have ratified the action. Ratification is an act of confirmation. The person who acts has to act as agent, and unless there is a principal at the time of doing the act, the person acting does not act on anyone's behalf. Before ratifying the act done without authorization, the principal should know the facts and the nature of the act that has been done on his behalf or in his name. The act must be ratified fully. One cannot be selective about the pros and cons of the act while ratifying. The principal cannot plead mistake or ignorance when he ratifies an act because he is deemed to have ratified the act only after knowing all the facts and the nature of the act. The principal must be competent to ratify because the ratification dates back to the time when the act was actually done. Illegal and void acts cannot be ratified. When one acts on behalf of another, it may be with authority or it may be without authority but subsequently ratified by the other. But ratification does not relieve the agent from liability to third parties. The liability of the principal and agent are joint and several, that is, they are individually as well as jointly liable for the act. Now, coming to liability by relationship, this exists between a master and a servant, an owner and an independent contractor, a principal and an agent, a company and its directors, a firm and its partner, and between a guardian and his ward. Let us first understand the rules of liability governing the master-servant relationship. Who is a servant? A person employed by another to work for him and is controlled and directed by him regarding the manner in which the work has to be done is a servant. An employee would be servant when his superior is authorized to tell him what to do and how to do it. A contract of service creates master and servant relationship, and this is different from contract for service. In contract of service, the master has the power to select his servant, pay his wages or remuneration, exercise control over the manner in which the work has to be done, and also to dismiss or suspend the servant. Under a contract of service, a man is employed as a part of the business, but under a contract for service, the work is done for business but is not integrated with the business. It is only accessory to it. For example, an owner of a showroom employs certain persons as salesmen. Here, the owner selects them, pays them, and tells them what to do and how to do, and hence they are servants of the owner who is their master. And here it is a contract of service. But where the owner engages an electrician to light up the shop, The owner engages him, pays his remuneration, and tells him what to do, but how to do it is the job of the electrician to decide. Hospitals are responsible for the negligence of their nurses, resident doctors, radiographers, part-time anesthetists, and special consultants because they act on behalf of and for the hospital and are a part of the hospital. But where you go to consult a doctor in a clinic, you are engaging him on a contract for service, and therefore there is no master-servant relationship between you and the doctor. There is no master and servant relationship between an employer and an independent contractor, between the employer and the servant of an independent contractor, and between an employer and subcontractor, because in all these cases the employer has no control over the manner in which the other has to perform the act. When the employer lends the servant to an independent contractor, he does not exercise control over him. And whenever the employer is compelled to employ a person by law, the employer has no choice, and hence there is no master-servant relationship between them. When the employee engages another person to do an act without being authorized by the master to do so, there will be no master-servant relationship between the employer and the unauthorized doer of the act. No master-servant relation exists between fellow servants, even where one of them is superior to the other. A father or guardian is not a child's master unless the child in fact acts as his servant. When a master lends his servant to a third party temporarily, whoever has authority over the servant to control the manner in which he has to do the act would be the master. Now, if the hirer takes the control, he would be the master. If the original master retains the control, he would continue to be the master of such person. In the case of car owners, the owner would be liable if he delegates the duty of driving to another, if he exercises control over the acts of the driver, and if he allows another to use his car for his business. Here, the driver is an agent or a servant of the owner, and hence the owner is liable. The car owner would not be liable where the owner's car is used by the driver for his own purpose, or the driver is under the control of someone else. Here, the driver is not in the control of the owner, and hence the owner would not be liable. In India, the owner of the car would be liable to pay damages for an accident by his servant, that is, driver employed by him in the course of his employment. The owner of the car would be liable if his driver in the course of his employment committed a breach of duty, either because he did not prevent another person from driving the car or because he neglected to ensure that the other person drove the car properly. A person who commits a wrong will be liable for it even if he is acting as a servant or agent of another or for the benefit of another. The person who suffers the wrong can therefore bring an action against the master and servant or against any one of them as he chooses. Thus, A, who is the servant of B, while working for B, acts negligently and causes injury to C. C can sue A and B jointly, or only A or only B for damages for the injury suffered by him. Prior to 1943, when an employee suffered injuries because of the negligence of another employee engaged in common employment under the same employer, the employer was not vicariously liable for the injuries caused to his employee by another employee. This was governed by the doctrine of common employment. This doctrine has been abolished by Law Reform Personal Injuries Act 1943. In India, the doctrine of common employment is not applicable. Under common law, that is the English law, there are certain duties imposed on the master. There is a duty to take reasonable care to provide adequate material and resources for work and ensure that they are maintained in proper, suitable and workable condition so that the servant is not exposed to unnecessary risk which could be foreseen or anticipated. There is a duty to inform the servants about all the dangers involved in the work which is known to the master. There is a duty to appoint competent servants and not to retain incompetent servants. After the passing of Workmen's Compensation Act, Factories Act, and allied enactments, the worker is in a better position now. The master is vicariously liable for the acts done by his servant when it is done in the course of employment. An act is said to be done in the course of employment if the wrongful act is authorized by the master, or the wrongful manner in which it is done is not authorized by the master, though the act was authorized by the master. The servant is liable to the master for the wrongful acts done in the course of employment. He is also liable to the person injured by the wrongful act. Therefore, A, the servant, that is driver of B, while driving negligently hits C and causes injury. B, as a master, is liable to C along with A, his servant, and A is liable to C, the injured party, as well as to B, his master, for his negligence. In order to hold the master liable for the act of the servant, the test is whether the initial act of the servant was expressly authorized and lawful. If it is so, the master is liable. If the mode of doing the act was not proper, but was done in the course of employment, and the act was not an independent act having no connection with the master's business, the master would be liable. For example, where B, the driver of A's car, while driving A to the office, negligently hits C's scooter and injures C and causes damage to his scooter. Here, B was doing a lawful act, that is driving in the course of employment, that is driving the master to his workplace, and hence A, the master, would be vicariously liable for the injuries suffered by C. When the servant does the wrongful act with spite or vengeance, it is not done in the course of employment, and the master will not be liable for such act. Authority may be implied or may be disclosed from the circumstances. Master will be liable for the act done by the servant in the course of employment. The act may be a natural consequence of the act done by the servant with ordinary care on the orders of the master, or as authorized by the master. The act may be because of servant's negligence in carrying out the duty for which he is employed. Where the servant departs from duty, the master will not be liable. Where the cleaner of a vehicle drives the vehicle and causes accident, the owner of the vehicle will not be liable because the cleaner has departed from his duty. Even where the act of the servant amounts to excessive or mistaken execution of master's lawful authority, the master would be liable for the servant's act. But where the servant does the act with personal rivalry or ill will, master would not be liable for such act. Master would be liable for the act of his servant even if it is done recklessly or improperly, when it is within the scope of employment and in execution of the work entrusted to him. But the master may specifically direct a servant not to do certain acts, and when such acts are done, the master will not be liable. Fraud or deception committed by a servant is within the scope of employment, whether done for master's benefit or not, and would make the master vicariously liable. Even where the act committed by the servant is a crime or an illegal act, the master would be liable for the act if it is done during the course of employment and is within the scope of employment. But where the master does not have control over the acts of the servant, as he performs the duty imposed upon him by law and not entrusted by the master will not be liable for the wrongs committed by the servant. These are some rules pertaining to vicarious liability created by relationship of master and servant. The remaining ones will be explained in the next presentation. Thank you.